We're back from recess. Majority Leader, you're recognized.
Assiduous Masi, Madam Speaker. Notwithstanding the rules, I move that we go into the Committee of the Whole on the urgent matter of the Attorney General's withdrawal from legal representation of Government of Guam departments and agencies in which the OAG has active criminal or civil investigations, which has resulted in a threat to the welfare of the people of Guam, and to call in the Attorney General to answer questions in the Committee of the Whole.
On that motion, Senator Taitzagui.
Thank you, Madam Speaker. Madam Speaker, I'd like to make a slight change to that motion, and just to that the discussion be regarding Bill 206.
All right, on the amendment to the motion to limit the discussion to Bill 206, is there any objection? So,
Madam Speaker, I just have a question.
Senator San Augustine, you're recognized.
Just a simple
State
question.
your point of inquiry.
The inquiry is that we're going to call the AG about 206, but are we not calling GPA in also on 206? It's reference to GPA. I'm just trying to make sure there's balance. I understand why we're calling the AG, but I'm just saying, we call the AG and it's on 206, then we call GPA in reference to the same bill. That's all I'm asking.
Thank you, Senator. On the motion, is there an objection?
On a point of information, Madam Speaker, if I may.
Yes.
The motion was made to bring the Attorney General's office, then an amended motion to that was to only deal with Bill 206. The last time we were here, before lunch, the bill was set aside, and you need to bring it back. So there needs to be a notwithstanding motion to bring it back to the second reading if it's set aside.
It's still there.
I know, but the motion needs to be up to further discuss because we set it aside.
It's still there, Senator. So on the motion, is there an objection as amended? There's an objection as amended. All in favor of bringing in the AG only on Bill 206, please raise your hand. Motion fails. On the motion to bring the AG in on the emergency conditions, is there any objection? There's one objection. All in favor, please raise your hand.
Madam Speaker,
Yes.
the motion to bring in the Attorney General of Guam to speak on what issue? On the issue before us? Are there any bills to that the Attorney General can speak on based on the letter that you submitted on the waivers, on 3 bills that were submitted today for waivers? Are those the reason why the Attorney General's office is going to come in? That is my question.
The motion is to bring the Attorney General in, and maybe the profferor can restate the motion, but there are no bills on second reading except for 206 right now, and this is to help us to determine which bill to bring in.
Yes, again, Madam Speaker, the motion is notwithstanding the rules to bring in the Attorney General to answer questions regarding the urgent matter of the Attorney General's withdrawal from legal representation of Government of Guam departments and agencies in which the OAG has active criminal or civil investigations which have resulted in a threat to the welfare of the people of Guam. So again, notwithstanding the rules.
Assiduous Masi. On that motion.
Point of order. Point of order.
Yes, state your point of order.
Thank you, Madam Speaker. Madam Speaker, I appreciate and I recognize it's a notwithstanding, but there's a big difference, there's a stark contrast between the emergency session and the emergency meeting. Emergency sessions, Madam Speaker, that whole process is set to be able to discuss a bill that is before us. There is no bill before us. There was bills that were waived, but there was no bill on the agenda before us other than 206. So the only way that it can happen is if the individual discussion is limited to matters that are on the session agenda. Other than that, it violates every facet and every rule within an emergency session.
There's an objection. All in favor of the motion, please raise your hand. Motion fails. Majority Leader, you are recognized.
Sujus Masi, Madam Speaker.
Majority Leader, you are recognized.
Okay, I'll yield to Senator Parkinson.
Thank you, Madam Speaker. At this time, I'd like
Senator
to...
Parkinson, yes, you have a motion?
Yes, ma'am. At this time, I would like to make a motion to move Bill number 206-37 LS as amended on the floor, or as I'm sorry, LS to the third reading, and vote on it today, ma'am, and put it to the voting file.
Third reading. On that motion, is there an objection? There's an objection. All in favor, please raise your hand. Motion carries. Senator Barnett, you're recognized.
Ma'am, I'd like to make a motion notwithstanding for reconsideration of the motion to bring the Attorney General in. Here, it's true we don't have a bill in front of us. We actually have several bills in front of us, and I don't think we can make a responsible decision about how to dispense with this issue that has arisen with the Attorney General's office until we hear from the Attorney General himself unimpeded and unfettered by interruptions, ma'am. So again, I would ask the body to reconsider the motion, and I just wanted to add that little explanation on there. I think that the people of Guam want to know, and we deserve to have the Attorney General here in front of us to answer all of our questions about this situation so that we can make an informed decision about which bill or how to proceed forward. Thank you, Madam Speaker.
On that motion to reconsider, is there any objection? There's an objection. All in favor of reconsidering the motion, please raise your hand. Motion carries. On the motion to bring in the Attorney General in the Committee of the Whole, is there any objection?
There's an objection.
There's an objection. All in favor, please raise your hand. Motion carries. We will now go into the Committee of the Whole. Hello? We're now convened in the Committee of the Whole. We're going to have the Sergeant of Arms swear in the panel. Senator Fisher, you have a...
Thank you very much, Speaker. I have a motion to make.
all right, if we can put that on hold, we'll have the panel sworn
After
in.
they're sworn
and I
in?
will announce the rules, yes.
Can you please rise and raise your right hand?
After they're sworn in, I can.
Under penalty of perjury, do you all affirm that any and all information you provide today, whether it be verbally, electronically, and in writing, be the truth, the whole truth, and nothing but the truth? Madam Chair, under oath, you may proceed. Thank you.
Thank you, Sergeant of Arms. All right. Senator Fisher,
Yes, thank you very much, Speaker. Ma'am, I move to allow agency counsel, in this case, Mr. Jordan Paloon of the Guam Memorial Hospital.
Objection.
Guam Memorial Hospital Authority, as well as Marianne Willischuk, who is the attorney for the directly affected agency in this case, which is the Guam Power Authority.
on that motion, is there
Well,
an objection?
I'm
There's
not
been
done.
an objection.
I'm not done. I'm waiting for order up there. Additionally, Jackie Terlahi, who's the president of the Guam Bar Association, would like to testify, as well as Jay Ariola, who is the litigant responsible for the conflict that the Attorney General is alleging. That's my motion.
On that motion, there's been an objection. All in favor, please raise your hand.
Hey.
Motion fails. All right, we'll now proceed. We're going to allow, I'm going to read the relevant part of the declaration, or our call to session. And that's without boring you and reading everything. I'm just going to read the first paragraph that says, whereas the devastation and destruction from the typhoon's passage, including the interruption of power and continued risk of load shedding, still pose a threat to the welfare of the people of Guam. Additionally, the urgent matter of the Attorney General's withdrawal from legal representation of government of Guam departments and agencies in which the OAG has active criminal or civil investigations has resulted in a threat to the welfare of the people of Guam. And in light of that, the above, Speaker, I certify emergency conditions exist which justify an emergency session. Attached was Bill 206 and accompanying documents from the sponsor of the bill submitted to the Speaker. Also submitted was a February 28, 2024 letter from the Attorney General to the Honorable Lourdes A. Leon Guerrero, Governor of Guam, in there citing a conflict or his immediate temporarily withdraw from representing departments and agencies in which we have active criminal and or civil investigations, effective immediately until such time as the before mentioned criminal cases authorize our office to provide legal representation in both prosecuting government officials accused of corruption and also providing legal advice to to that same department or instrumentality that the government officials work for. We will be temporarily withdrawing from providing certain government departments and instrumentalities any legal services to avoid any ethical violations until the courts resolve the issue. We urge you to secure independent legal counsel to provide for your legal needs until such time as the judiciary, including the Supreme Court of Guam, can provide a clear statement on our ability to prosecute government officials and simultaneously provide legal services to government departments and instrumentalities whose officials are being prosecuted or under investigation by the same elected Attorney General, all under the Guam Rules of Professional Conduct. For any document that requires the AG's office signature, we will simply insert on the signature line, quote, potential conflict, cannot sign, unquote. We do not provide to you a legal opinion on whether Guam allows for processing the document without the AG's office signature and recommend that you seek the assistance of an independent counsel. The full letters have been distributed to all the senators and have been placed on messages and comms. Again, this was a letter, February 28, 2024, to the Governor of Guam from Douglas B. Moreland, Attorney General. Attached to that is a list of 21 agencies titled Government of Guam Instrumentalities under Investigation by Office of the Attorney General. There were additional documents sent to us by the Attorney General of Guam. All of those are up in messages and comm as well. At this point, I'm going to ask the Attorney General to, I'll state the rules first. I'm going to ask the Attorney General to brief us on this letter and this issue, and then I'm going to open it up for 2 rounds of questioning for all senators. Attorney General.
Hafide, and thank you, Madam Speaker, and thank you, senators, for this opportunity to explain a situation that is facing the Office of the Attorney General and our ability to perform the legal services as required by the Organic Act. For clarification on the record, the first document that was sent was on February 28th to 22 government departments and agencies that resulted from criminal and civil investigations that are going on with the Office of the Public Auditor, as well as investigations that had been engaged in for about the past 12, 13 months by the Office of the Attorney General based on different reports that we had been receiving. There is a February 29th letter that you should have in front of you as well that identifies the 22 departments and agencies. The 22nd one is the Airport Authority. And in that 2-page letter, we specifically identify a process in which these contracts and procurements can go through our office. Basically a disclosure letter that provides the department or the agency head can sign off on it, understanding that under Guam law, we wear the hat of a check and balance in the system so that we're not their lawyers by effectuating 3104 of Title V Guam Code Annotated, which requires the Attorney General to be the public prosecutor and to investigate public officials specifically. Under 3109, it also provides that in addition to being the public prosecutor, the Attorney General is to provide legal services for the agents of the government of Guam, which are the people of Guam, and they're synonymous. It does not say that we are the attorneys for any individual government official. However, this issue is currently before the court based upon 2 government corruption cases that we had initiated last year and is pending decisions by 2 judges. I will make it very clear right now that it is my opinion, my position, and the AG's office position that we want to wait for the judges to act. We have 3 versions of what has occurred. The second one is the February 29th 2-page letter that I just identified, where the agency official can sign off on it. I met with the governor and got the feeling from our governor that she was not going to let any of her cabinet and agencies sign off on our disclosure letter. I have worked with my office, and we are going to be processing every document that is submitted to us, but with a stamp essentially disclosing that we are not representing the government officials, but are doing our duty under the requirements of the Guam Legislature to ensure that these contracts are reviewed for legality and that any impropriety in them is also reviewed by our office. This is out of an abundance of caution and in recognition of the Guam rules of professional conduct. So, Madam Speaker, Senators, the situation, in my opinion, does not require the action of the legislature, and I thank you for calling an emergency session, but I do not believe that it's actually necessary at this point, but I'm prepared to address any questions you might have. We will be processing every document as long as they're, as usual, making sure that they're legal and are in the proper formats. And I think we've processed, well, I guess the focus is the 22 departments and agencies. Those will be processed and they will have a stamp on it, basically getting our approval, the Attorney General's approval, that the contracts can go forward or the procurements can go forward. This emergency legislation that you have in front of you, I will comment that having been an Attorney General before, and 20 years have gone by, The people of Guam, through you, your august body, have built in additional safeguards into the system so that government corruption investigations aren't at the tail end of where the money and the expenditures have already occurred and have been upfront investigated, so the AG's office reviews it. The over 500,000 for agency contracts normally in the past would not require the Attorney General's review and approval. A legislature between the last time I served and now has included it. The last AG was signing away the authorization to what they call the private attorneys through SAGs. When I came in, I withdrew all of them. The SAGs, the private attorneys do not have the same type of purview that an elected Attorney General has. The elected Attorney General has the ability to prosecute and to uncover corruption and to enforce the laws. Private attorneys are not held to that standard. They do what their client tells them, which is the person that signs their check. They give the legal advice and let the client decide. The Attorney General's office does what you senators have told me to do, which was to look for any impropriety and to stop it. It's the check and balance. It's the watchdog. It's all those things that we want to do as a community to prevent the money from having been spent and the low likelihood that we're going to get back the money. So that's the idea that the process that you are speaking to. The generation equipment that you're talking about, I have Deputy Graham Botha here that can explain the potential problems of not having the AG's office look over this procurement. Rushing to procure this amount of equipment, it just reeks of the possibility of errors and possible sweetheart deals that are built into these type of emergency procurements. But it is your decision to make. I just say that we're ready to review it if you want us to review it. I've heard these complaints about 5 days, 10 days. I can tell you right now with my staff here, whenever anybody calls me up, calls any of our staff up, including the Civil Division, says that they need to expedite a contract, it's out. And a few of you senators have actually called me. We've kicked it out. You know, we're about customer service in this department. We're making sure that the recipients that benefit from the contracts get out. So I've got a good team behind me. They're here today to answer the broad spectrum of what you may have in terms of questions. And thank you.
Thank you. Could you please introduce your team?
Thank you. To my far left is Fred Nishihira, one of our deputies handling the Department of Education. I have Graham Botha, who's also a deputy of the Civil Division. We have our Chief Prosecutor, Gloria Rudolph. I have Nathan Tennyson, a deputy of the Appellate and Writing Division, which is dealing with this government corruption cases and the appellate writing that's going to have to be expected on it. I have Joe Guthrie, my Chief Deputy, to the left, as well as Lee Miller. He is one of our attorneys in the Civil Division. We have also Tiffany Browning, a new attorney in our Civil Division, as well as another attorney from our Appellate and Writing Division, Danny Morris. Thank you.
All right, we'll begin questions. Would anyone like to go first? Vice Speaker, do you want to go first?
Well, Vice Speaker, thank you to the panel being here. Attorney General, thank you. And in light of the presentation just provided by the Attorney General, I think that there should be a motion in order to excuse, and if this is not necessary at this time, that we excuse the panel and move forward with whatever else is on the agenda. So I just want to thank the Attorney General for the presentation, but if it's the matters for the judicial branch to look at and further give their decisions based on what's presented and before them, then I think that we should respect that process. Thank you very much and ask that they be excused. That's a motion, Madam
Thank you.
Speaker.
On the motion, is there any objection? There's an objection. All in favor, please raise your hand. Motion fails. Senator Taitui, you're recognized.
Thank you, Madam Speaker. And I thank the Attorney General's office for all your hard work. It definitely shows to the people of Guam the work you're doing. We greatly appreciate it, and I know you're very understaffed too, so I also greatly appreciate the time that you take away from your family to address the issues here on Guam, knowing that you are short-staffed. Greatly appreciate it. I do understand that we received letters from the Attorney General. Thank you so much for alerting us to that, the concerns. And we do have the opportunity, again, I'm hoping, after we get more information put forward. But there are a couple questions I have because, as you know, we want to address any concerns that the Attorney General has with regards to a conflict of interest. It's one of my biggest concerns. Secondly, on Bill 206 that we had in front of us, that you mentioned that you will be looking at this expeditiously to ensure that, well, the only problem is, and if you can just curse your view, and I've never seen so many attorneys in front of me before, is there, and I'm sure, since you had a lot of time in the public hearing room waiting for us to speak to you, could you tell me, Attorney General, do you see anything in front of you on Bill 206 that would alert you to any, I call shenanigans, or anything that would avoid the Attorney General to stop or put a stay on this procurement?
Senator Teitigui, in regards to what I have in front of me, the two-page proposed legislation by Senator Parkinson.
Sorry, we're going to take a 1-minute recess. The bill was amended by committee, so you need to review that.
Thank you.
Okay. We're back from recess. Senator Taitsui had asked a question regarding Bill 206 as amended. There was also another amendment made on the floor to change 48 hours to 5 working days, no, 5 calendar days, and an amendment on line 14 after 5215E to add is extended for 2 years for this procurement only.
Thank you. Madam Speaker, I've consulted with our staff, and I believe that the 2 amendments are appropriate and can be complied with. My understanding is that our office will be capable of reviewing it within a 5-day period and be able to communicate with the CCU GPA regarding any problems with the procurement. Am I correct, Graham?
Yes, just to note that basically what we'd be reviewing is the contract for this approach at last 5 calendar days because they're ready for award. So basically the normal review, just so senators are aware, phases 1 through 4 for a regular.
Could you pull the mic close, please?
I'm sorry, as the senators may be aware, for a normal review, if it's anything over 500,000, we're required to review all phases of the contract. But since this contract is now ready for award, as we've heard from GPA, we'd be reviewing the final contract within the 5 calendar days, if that's acceptable, senators.
Senator Taitsui, you have the floor.
Thank you. Can you also make a comment on the 2-year amendment that was incorporated into this bill too?
Well, the 2-year provision, as I understand it, is the contract, the proposed contract with the Greco International is for 2 years of temporary power. Now, under emergency procurement is clearly limited to 90 days. And with perhaps after a legislative hearing, maybe you could get 1 additional term. So it has to be extended. Otherwise, it should have been done under a normal procurement, but it was done under an emergency procurement, which is only good for 90 days worth of goods or services.
So okay, then it's basically normal, but because it's an emergency procurement. Okay, and it is the length of the contract. Is that how you read it?
That's correct, but
okay.
Normally, if you were going out to procurement, you would not procure, you would use a different form of procurement if you needed services for 2 years. You would generally use the emergency procurement for something that's needed right away, say after Typhoon Marwar, and it would be only for a period of 90 days. And the procurement code cites that within that 90 days, you would look to procure the goods and services through any other method of procurement, but not an additional emergency procurement. So that's why the bill needs the waiver to increase it to the 2-year period as the contract proposes for the temporary emergency power with the Greco International.
Thank you. Thank you so much for that. So, Attorney General, in the event within that 5-day period, you have a chance to review the final contract. And if there is something that is not in good standing or the best interest of the people of Guam, can you stop it?
Yes, it would be. A letter would probably come out from our civil division indicating the problems with it. This is an important procurement for the people, as you senators have identified. So Mr. Botha being present right now, we'll make sure that any anomalies are put into letter form and sent back to the individuals that have sent it to us, GPA.
And would there be like a stay that the Attorney General can put into place if you find something, anything wrong?
That is correct.
Okay. Thank you.
Senator.
Does the CCU, the PUC have anything to do with that too, that you alert them as well? Because they have to go through the PUC, I believe, whenever they are approving anything, right?
Thank you. I will request that Deputy Botha also copy it to the PUC.
PUC.
Any communications of any problems with the procurement.
Thank you. Thank you, Mr. Attorney General.
Thank you.
It's a little bit more comforting to know. The other question, well, actually, when the Organic Act provision for the elected AG was passed, it was specifically to take away all the legal functions for the governor, because the governor has historically meddled, in the AG's functions. And the U.S. Congress history has shown that this end has been recognized by the Guam Superior Court too, as well, Supreme Court as well. When the legislature provided for the CLO, and for those who don't know what CLO is, it's the case legal officer, and the PP, which is public prosecutor, to combine in the Attorney General. They understood the tension in that the AG and the CLO might render advice, and as a PP, might prosecute an official. That being said, can you explain in the Guam Code Annotated, Title 5, Chapter 30, Section 30180, please?
Thank you, Senator. Are you referring to the,
Or 30108.
correct, the
my
defense
bad.
of judges, officers, and employees?
Yeah, this is on yeah,
Yes.
30108, yes.
Correct. This is a statement from the Guam Legislature, and this was passed, my understanding is back in 1975, before the Supreme Court became an Organic Act Supreme Court of Guam, and when I believe the governor had just become the governor, elected governor in 1970. 3108 talks about, essentially, it gives the legislature's stamp of approval that the Attorney General is to protect the interest of the government, and if government employees are somehow worthy of having the services, legal services of the people through the Attorney General's office, that it can be provided under these terms and conditions. It also recognizes that if a government official is supposed to be prosecuted or, how is it put, the Attorney General to decline the defense of any of the above officers or employees on the grounds that the criminal prosecution or disciplinary action requiring action of the Attorney General. These are the types of mandates that will be argued and have been argued before our Superior Court of Guam and may go to the Supreme Court of Guam, that this is part of the separation of powers. This is what existed in Guam law. This is a reflection also of the federal U.S. Attorney General, which is Merrick Garland, and at least 3 states in the United States that have small populations like Guam, where you mix the duties of the Attorney General with criminal prosecution and also providing civil legal advice. So this section you've cited embodies some of the ethical issues that we're now discussing in the courts. Thank you.
Thank you so much for that clarification. Attorney General, my time's almost up, so I'm going to ask for this letter that was sent to us from the Supreme Court of Guam. If you can explain that, please.
Yes. The Supreme Court of Guam, and this is part of that legal analysis that we've been doing in the AG's office. The attorney for the Supreme Court of Guam is noting the Organic Act significance that the judiciary controls the licensing of attorneys. However, the Attorney General, and I'm not talking about this Attorney General, all Attorney Generals are a creature of the executive branch. The legislature has mandated in almost every state quite frankly, that an Attorney General shall be representing the people of that jurisdiction. And what we call it is protecting the public interest. That is the duty of the Attorney General. It's not representing an individual person. The Supreme Court of Guam, when it became into existence the second time around, where the Congress actually allowed it, was, I believe, 1998, if I'm not mistaken. In 2003, the Supreme Court of Guam passed the rules, the ethics rules for we attorneys. In that document, and I have a copy here, this is the rules for attorneys to operate under, the professional rules that are referenced in our letters. Nowhere is it referenced the statutory requirements in the statute and the unique nature of an Attorney General. An Attorney General is a public attorney. It's not equivalent to a private attorney. And that's been recognized through cases in different jurisdictions. And obviously they come down in different areas. Guam has specifically talked about it by creation of the enabling law in 1975 for our Attorney General, which is public prosecutor and a civil attorney. So in a 2005 case, there's actually 2 2005 cases from the Supreme Court of Guam, the airport decision that we call it, and also the Brooks decision. The Supreme Court of Guam recognized that there are certain areas that it's adopting from the statutes that were in existence when the 2003 model rules were adopted. And the Brooks decision talked about that. So I feel confident that the Supreme Court of Guam is going to make a positive decision for us on this. They have at least one 2018 case as well that was with General Barrett Anderson against the Department of Revenue and Taxation, and they came down in favor of the Attorney General having a unique position in our system of government. Again, note that a private attorney, when they provide advice to a government official, they're providing advice to the government official. When an Attorney General is involved, like the assistant AGs or the deputies that are sitting at a table with other government officials, they are a watchdog to protect the public interest, because that government official and we represent the people of Guam, and we do not represent the government official, hence the reason why we can prosecute them and bring them before a grand jury and so forth. So that scheme, again, is not referenced in our model rules of professional conduct, and what they call is an imputed disqualification. A normal attorney, when they have one of their associates that has a conflict, it would normally transfer to the principal of the law firm, so the whole law firm would be disqualified. In this case, they call it the Barrett-Anderson versus Camacho decision, 2018, by the Supreme Court. They didn't find the imputed disqualification that just because then Assistant or Deputy Mason had a conflict, that conflict didn't transfer into the then Attorney General Barrett-Anderson. So, yes, that is our kind of response to your question there. I believe that the case authority exists, but quite frankly, I believe at some point the Supreme Court of Guam may be incorporating some of its decisions into an updated version of the Guam Rules of Professional Conduct. Thank you, Senator Taitigui.
Thank you so much for that. There's also, the letter that was sent to us, I believe, or, a letter that I had received on the February 28th regarding, conflict of interest.
Yes, and that's why the attorney for the courts, and this would normally go before the justices or the judges in the Superior Court. This is an attorney's reminder that the judiciary of Guam, the Supreme Court of Guam, is of a constitutional level. As you senators are well aware, the enabling legislation by Congress, also at that Organic Act level, passed in 1999. And then it gave the option to the senators to make it an elected office, which the senators did do, because they felt that the governor should not be the one that appoints and removes an attorney general. There's some remnants in it. If the AG leaves early in office, the governor might, or later in office, the governor may be able to appoint for that duration. I think it's happened one time in the history of the attorney generals. But clearly, there's a statement in Guam law that an attorney general needs to be directly accountable to the people, not accountable to the governor. For the last 22 years, the Attorney General has been always elected. The legislatures in the past have never broken the office up. And one of the bills that I've seen, that I think is 254, that is a midnight massacre of the Attorney General. You're going to create 3 different Attorney Generals on Guam, and you do not want more lawyers on Guam controlling these type of issues. One person that's answerable directly to the people, and not to the governor, has been a system of government that has worked for most every state in the United States has elected attorney generals. They do not follow the federal model, which was the original appointed attorney generals. They've moved away from that because there's a cleansing effect that occurs when you have an elected attorney general that's willing to question and scrutinize and be the check in the system against government officials. So thank you.
Also, can you explain the judge magistrate for Joaquin Manabusan's comment previously held at the Attorney General of Guam? It's faced with the potential. Yeah, can you also explain that scenario?
In the Santos decision, which is another 2005 decision, the federal magistrate judge, Joaquin Manabusan, retired now, had a conflict situation in front of the judge. That case was unique, though, because the governor, under the Organic Act, controls taxation. And in that case, the question before the court was whether or not the Attorney General had a role in the taxation, and the court found that the Attorney General did not, because the Organic Act specifically carved out taxation under the control of the governor. So I believe it was the governor's councils at the time wanted to disqualify the Attorney General, and the court, Judge Joaquin Manabusan, came down and said, he memorialized what I say all the time and what other AGs say and what all jurisdictions recognize. The Attorney General protects the public interest. They protect the people above all other interests. If faced with a conflict situation, that the AG must choose between defending a government official if their conflict exists, which, by the way, we don't believe a conflict exists. But if you're in that situation, and again, that case, the client was the taxation, which was the governor's control, the AG must always protect the people, protect the public interest. That is what Judge McKinnon-Manabusan, I believe, correctly decided and consistent with many elected attorney generals in our nation and appointed attorney generals. The only problem with an appointed attorney general, the power to appoint is the power to remove. So if the AG doesn't do what the governor or appointing authority wants, they literally could be removed.
Thank you. Thank you so much for that. And thank you, Madam Speaker. I'll wait for round 2 for my next set of questions. Thank you.
Thank you. Senator Fisher, did you have questions?
Yes, thank you very much, Speaker. First question, I guess, would be to Mr. Bota. I know that you were the attorney, I guess, for Guam Power Authority, or was it CUC, for a number of years. Is that correct?
Yes. Yes, for GPA.
For GPA? Okay. Is it fair to say that in the course of your duties with GPA, you have reviewed procurements that the Guam Power Authority might have wanted to carry out?
That's correct.
I'm sorry.
That's correct.
Okay. Have you ever assisted in a temporary procurement of a thing by GPA?
Well, as a matter of fact, in 2015, I did assist GPA in procuring temporary power.
Okay.
However, it was not done through an emergency procurement. It was done through a regular invitation for bid. The invitation for it was a multi-step bid. It was put out in an expedited fashion, but not through emergency procurement, and it was passed. And I think the generators, in fact, the same companies that's at issue here, Greco International, the generators landed on island within 4 months
Okay.
of the bid.
All right. Thank you. I was just actually I just was kind of drilling down to find out. You had said, I think your office says that you will be able to accomplish the review of this procurement within 5 days. Is that correct?
Well, no. I think what it was is we'll be able to review the final contract. The procurement's already been done.
Okay.
This emergency procurement, as my understanding is, they're ready to award, given if the governor signs off on the emergency declaration, then GPA is ready to award the bid to Greco International.
Okay.
So there's no procurement review to be done.
Okay. So
That's already been done.
okay. So the procurement review has been done by, was it by your office?
No, it has not been done by our office. It's basically been done, I'm sorry, am I not speaking loud enough? The procurement has already been done by GPA.
Okay. Sir, when this, in the event that this comes before you, will you also perform a secondary review of the entire procurement, including the invitations, et cetera?
Well, given all the waivers that are here, I mean, basically most of the provisions have been waived or proposed to be waived by, Bill 206.
Okay. Yeah, the reason I'm asking these questions, sir, is because Bill 206 is designed to alleviate a hardship which the people of Guam have been going through for some time, which are, the rolling blackouts. And most of us are very enthusiastic to get this going because, if everything goes according to Hoyle here, we'll be able to put an end to the rolling blackouts. So I guess I'm just going to ask you, can you get this review done in 5 days?
We can certainly review the contract in 5 days.
Okay. All right. Is there anything you're going to need to review beside the contract?
Well, we need all the rest of whatever procurement documents have been done.
Okay.
We need to see those as well, obviously, to make sure that the contract, usually for most procurements, there is a sample contract attached to it, as part of the bid. So you'd want to make sure that the final contract does not deviate too much from what the bidders were actually supposed to be bidding on.
Sure.
So that would certainly be necessary.
Okay. So can you do that within 5 days?
We'll certainly give it our best effort to we'll certainly review the contract, and we'll do our best to review all the rest of it.
Okay. Fair enough. I understand your response. If, for whatever reason, things happen, the review goes beyond 5 days, do you think the agency has any recourse? In other words, basically to make you guys do it. Or if you don't do it, just go ahead with the procurement.
Senator Fisher, if I can comment on that a bit.
Please.
On this specific one, Mr. Botha was brought here specifically to address your concerns, and we will get it out within 5 days. But when we say get it out, it may have to be kicked back because of some issue, some paragraph or something that needs to be reworded or clarified.
Okay,
so,
and I think that would satisfy the agency, sir, because they just need to have an opinion. I worry about a situation in which the procurement, no decision is made by the Attorney General's office for weeks and weeks and weeks, and we're still going through the rolling blackouts, et cetera. So in this sense, it is an emergency, and we rely on the Attorney General's, what you've stated, your word, you'll get it done in 5 days.
Yes, sir. Senator
Okay.
Fisher, that is my commitment. This is such a current matter. It's sent to me. I'll be held to my word, and our
Okay.
team will get it done.
Okay.
Madam Speaker, may I just make a point of information? Just the point of information is that at no time during discussion on this bill did we receive a yes or no answer about whether or not the measure would end load shedding, and I just wanted to reiterate that on the record. Sidos Masi.
Senator Fisher, you have the floor.
Okay, thank you very much, ma'am. Well, I think that it is our goal, it certainly is my goal, to do everything we can to stop the load shedding. It's a major inconvenience. You know, there are people who are obviously, you know, depending on electricity to run medical equipment. So load shedding is no good, and I hope that we can get it done. And thank you very much, Mr. Attorney General. Thank you for that commitment. I'd like to follow up on the Supreme Court's letter. The Supreme Court is obviously, and I have to take a bit of an exception, this was not a staff attorney's opinion. This is on Supreme Court letterhead. Did you all review the Organic Act before you submitted a bill waiving conflicts and attorney-client privileges?
Yes, we have. That was the dissertation that I just gave about the 2005 airport decision, the 2005 Brooks decision by the Guam Supreme Court. They talked about the old laws that dealt with the ethics rules and how they would still continue. And then they talked about how they have the Organic Act authority to control, you know, practice and so forth. The laws that I've just cited and that Senator Tydegui had mentioned, those are the old laws. That's part of the 1975 scheme of duties, responsibilities, and statements as to what we lawyers would consider a potential conflict. And the Guam legislatures of the past have said that you shall be one attorney general, you shall provide the legal services to these stewards of the public trust, the government of Guam, and if they violate the public trust, you shall have the responsibility to take them before a grand jury or take them into the court system and enforce the law.
Yes, sir. But I guess my question, though, is why did you review the Organic Act? The Organic Act is functionally our Constitution, and it specifically awards to the Supreme Court of Guam the ability to govern attorney and judicial ethics and the practice of law. I don't think anybody in this body thinks that we have the power to do what you requested, which is just by legislative fiat say there is no conflict of interest or there is no attorney-client privilege. This seems to be the Supreme Court's, I mean, they've shut the door, sir. There's just...
Well, this is not the Supreme Court, Senator Fisher, as you know. This is an attorney that's providing a reminder to the senators that this is the Organic Act. Just like the Attorney General is the Organic Act, what does Chief Legal Officer of the Government of Guam mean?
Do you think we should feel free to ignore this?
Of course not.
Okay.
It's a very important document, but at the same time, I'm holding, and I'll provide copies to you if you wish, In re James Brooks, ADC 03002. This was an opinion issued by that same Supreme Court that the letter came from, and all three justices, Benson, Torres, and Francis Gatewood, on July 19, 2005, said that some laws that are passed by the legislature dealing with ethical rules will continue to exist. And that's why I say that in that one-page, a recitation of the Organic Act, it has meaning through the Supreme Court of Guam. And also the airport decision. The airport decision is critical because it says specifically the Guam Legislature establishes the duties of the Attorney General. In that statement, the Attorney General shall be a public prosecutor, and that same person shall be the civil attorney for the government of Guam. So, you know, it's going to be subject to interpretation, and that's why I opened up by saying that I'm going to respectfully defer to our court system on interpreting all these. But we were just called in to address an important issue, and you know, we gave a proposal. And if you look at the bill as we presented it, it's just clarifying existing law.
Did the courts, the cases you've cited, did they specifically address the Organic Act powers of our Supreme Court to regulate the bar?
I'm sorry, Senator.
Yes, I'll repeat, sir. Did the cases that you have been citing, did they specifically address 48 U.S. Code 1424-1A6 and 7?
No, they don't provide any case authority, just a recitation of the Organic Act. But it has meaning behind those words, and obviously you know that it's case authority that defines things.
Well, I don't know if it was dicta or what, but sir, okay.
Sorry, Senator, you're asking about in the decisions, right? Not in this Superior Court letter.
No, I'm not asking about the decision. I'm asking, well, I'll just real quickly. Sir, with respect to what you've said, this impediment, this barrier, if you wish, of the Organic Act, I just don't think we can transverse it. We cannot award you a lack of a conflict of interest. That belongs across the street. So that was my point with that. That's what I was asking.
Madam Chair, I yield my time to Senator Fisher.
All right. Thank you. Senator Fisher.
Thank you very much, and I appreciate that, my friend Roy. So my only point, sir, is the Organic Act trumps. And the Supreme Court, I think, has made it very clear that they want us to stay in our own lane. That's the way I read it.
Well, again, these aren't the justices of the Supreme Court. This is an attorney like you and I that is making a statement, a reminder that what the Organic Act states. And I agree, this is what the Organic Act states, but it requires the interpretation of the justices and the judges of the Superior Court and the Supreme Court. That is lacking here. The attorney has not provided the case on point that's talking about the Attorney General has a conflict of interest when he charges a public official that has been provided legal services by that office. Okay. So that is what we're working towards in the court system right now.
Thank you. I wouldn't, just a cautionary note, I suppose, is I wouldn't ignore letters that come on Supreme Court letterhead quite so readily. I assume that this individual got the green light from somebody.
I'm not going to read into it, Senator Fisher, but I do take this very seriously, just like I took the licenses that we practice before that Supreme Court very seriously. We all know what the Supreme Court and the respect that they're due to follow the requirements of our license.
Okay, sir, that letter that you sent out February 29th, is that still operable? Is it still in force?
It is an offer to, every department that's on that 22 or agency on that 22 list, to sign off on it and to have it processed. Again, I had a conversation with the governor. She seemed very reluctant to allow her administration to sign off on these disclosure letters. So we're just going to stamp our statement on it with our signature if it passes muster.
Okay, we've been talking a lot about a conflict of interest. Let me frame the conflict. I'm sure there are other possibilities, but the conflict I understand that we are talking about is the Office of the Attorney General has been offering civil advice to the agencies, and in some circumstances, then turning around and alleging criminal activity based upon what you may or may not have heard. Is that in the course of your civil action? Is that the nature of the conflict?
The nature of the conflict, as is being alleged, which we disagree with, is that our office provided legal advice to a government official that is now been charged by the grand jury of violating a law. So we disagreed, and that is what we're before the courts, showing that, first of all, no attorney-client relationship existed between that government official and any attorney in our office. The statutory client is the people of Guam. These are stewards of the people of Guam. That's the whole scheme that's set up in 3104 and 3109. They talk about the civil and the criminal duties of the Attorney General.
Okay. So let me ask you to project yourself into the position of an agency head, any agency, that the Attorney General came to them and said, I'm going to begin asking questions in a civil matter. I'm going to be asking for documents in a potential civil matter, transfer of land or what have you. And then the agency head discovered you were using the self-same documents to prosecute them or a member of the staff. If, again, you're projecting yourself as an agency head. As an agency head, would you tell your clients to stop cooperating with the Attorney General?
If you have nothing to hide and believe you are following the law, there should be nothing stopping these government officials from fully cooperating with the people's attorney, the people's law firm.
Now,
if you have violated the law, and in several of our letters, we've recommended that you seek private counsel, which is the normal procedure. So the question is whether or not that government official enjoys the protection against being charged by the Attorney General because simply the Attorney General provided legal services to that government official. They are not the client. The client is the people of Guam, and that is statutorily. So it's a perspective that the criminal defendants feel that they can expand upon, and now our court system is going to have to define that. This is not a new question. This is a question that other jurisdictions have addressed. And again, I just cite that our old rules of professional responsibility passed in 2003 didn't catch this. They didn't talk about it. So as attorneys, we're being very cautious how we approach it because we have to wait till the final Supreme Court of Guam gives us the proper direction on
Yes,
this.
sir. Thank you for that answer, but it wasn't the question I asked. The question was...
Would they be reluctant?
The question was, if I'm asking you to project
Yes.
yourself as an agency head under the facts as I outlined them. The AG's
Yes.
come in, picked up some documents on a civil matter, and then turned around and indicted somebody. With that possibility, as an agency head, would you advise your agency to cooperate with the Attorney General?
Absolutely. The Attorney General, like the Guam Legislature, represents the people of Guam. When you call people before you, government officials before you, you don't want that government official telling his staff, don't appear before the Guam Legislature. Same thing with the Attorney General. We are taking those documents before grand juries, which are the people of Guam that are going to process it and then decide whether a case should go forward or not. At least when you're talking about the criminal side. But remember, there's also the civil side. If the Attorney General is doing a civil...
I'm sorry, sir. There's just too much going on here. This gentleman's trying to turn his phone off. Okay, go ahead.
Thank you. The idea is that the Attorney General can conduct criminal investigations and civil investigations. So in either case, if a government official receives a request for information, whether it's via a subpoena or just via a letter from the Attorney General asking, can you please provide us these documents? If the government official assesses themselves, believes that they may have criminal exposure, that they violated the law, they should seek their own attorney to talk about if they've broken the law.
Okay,
But just because the AG asks for something or a grand jury asks for something, they shouldn't be put in a position that we can't get the documents because of a potential liability. You know, it's one of those, introspective.
Okay, I have to quibble with that word. You said liability. You're actually talking about a potential criminal charge.
Well, no. There's civil investigations which have liability, and there's criminal investigations which have possible guilt exposure. Okay. So that's my context.
Okay, I do appreciate that. I want to ask you this question, and I don't want you to think that I'm being wise or smart. I know that you are a very experienced defense counsel, and I'm trying to explore your thinking on this issue. As a defense counsel, would you advise a client to go ahead and cooperate with the police simply because they believe they did nothing wrong?
In many ways, I might, depending upon the facts and circumstances. And this is like that is why we would recommend if a government official believes that there might be wrongdoing, that they call up their lawyer. I believe in DPW's case, we had the director, Areola, had his brother, Jay Areola, send us a letter. He chose to contact private counsel because of whatever potential liability he might or might not have had. I came back with a letter saying that you are not the target of any investigation, but we have a duty to ask questions, get documents, and that sort of thing. So You know, that plays out every day in the AG's office. We get tips from the public. The public auditor is very active on issuing audits. So that's just what we do.
Okay. A letter was written by the Guam Power Authority. I don't know that you've received it. It was dated March 3rd, which I guess was about 3 days ago. And I'll just read a section of it. And this is from Ms. Heighton. Yesterday, the Attorney General sent a second letter stating that he would not review any of GPA's procurement documents unless GPA management and legal counsel signed a waiver of legal rights. And now this is what GPA is saying, and it's very concerning. As a result, GPA management faces the prospect of either relinquishing important rights in the face of criminal prosecution or foregoing the Attorney General's review and approval of the temporary power project, thereby halting its progress and plunging the island into, and this will perhaps solve Senator Barnett's concern, and plunging the island into a summer of load shedding. Is there anything that you think is inaccurate in that?
Yes, absolutely. You characterized it, and I have not seen that letter, but you characterized it as a waiver of rights. Nowhere in the documents that it's now in the legislative record is this a waiver of rights. This is, and it has several provisions. It says, we will not serve as you nor your department's attorney in processing any documents. That's not a waiver of rights. That's a disclosure that when you send a document to be received by us, we're not going to protect you if we find corruption in it. And I believe that reflects the exact state of the law right now. We're not their lawyers. By reviewing our documents you transmit to the department, we are doing so to protect the public interest. You acknowledge that your department may be under investigation and that you're sending us the document for review and approval, and that we are not your attorney in this matter. And in doing so, your document you send to us might be considered evidence against you if there's wrongdoing that occurs. I specifically referenced the public auditor's report about GMHA. The Guam Memorial Hospital collections, millions of dollars were paid. The AG was not the attorney for those people that were transmitting the documents over. I believe former General Levin Camacho signed off on the contract, but was not involved in the actual procurement. The next disclosure we make, we reserve our right to criminally or civilly investigate and prosecute government officials in their personal or official capacities for any wrongdoings. That's just a disclosure. If you believe that you have any civil or criminal exposure, that we encourage you to get independent legal counsel. These are all disclosures. There's no waiver of rights in this.
Well, okay, sir, and I don't want to quibble with you, but I'm looking at the letter of February 29th in which you say you're required to acknowledge, consent, and agree to the following. We will not serve as you or your department's attorney. By our reviewing documents that you transmit to your department or the entity, the AG's office does so to protect the public interest, etc., not yours or your department. And you are requiring the agencies to agree to these provisions, and if they don't, according to the letter, the signature line will be filled in. Potential conflict, cannot sign. Is that the status of things today?
As I opened up, the February 28th letter was sent first, the February 29th disclosure was sent, and then the governor called me to her chambers in which Jeff Moots, myself, and one of my deputies was present. We discussed it. The governor had her reservations, which I respected, and then we came out with the decision. We will be processing them with the stamped disclosure. And it's going to indicate approved, not representing any public official.
Okay. All right, sir, I don't really have too many more questions except for, I guess, one, which is this. You know, the Department of Justice has been doing this function, civil and criminal, for 200 years. Most every other jurisdiction does the same. Why can't you set up a conflict wall between the civil side of the house and the criminal side of the house and not exchange documents, just a complete and utter divorce, so you can complete both functions? And then we wouldn't be here in this mess with the agencies not knowing whether or not they can function, with not knowing whether or not we can get a contract signed to feed the Menamco, not knowing whether or not we can keep the foster homes open. Why can't you just set up a wall?
Excellent question. Senator, because the rules don't provide for it, and this was thrown in our face at recent hearings before those two government corruption cases. The Guam Rules of Professional Conduct do not allow a principal lawyer to set up the conflict wall that you're talking about. That's number one. Number two is the people elected the Attorney General to himself, in this case, provide public prosecution and to also provide legal services to the government in one person. If you're asking an Attorney General to say that I will only handle civil and then find another person to only handle criminal, or I handle criminal and then you handle civil, the Attorney General is no longer in control. You have now appointed a person that no longer is under the direction of the Attorney General because you created a conflict wall. The conflict walls that you talk about in private practice are different than that. It's when an associate comes in, has a potential client, former client, that they want to prevent that attorney-client relationship developing with the principal, so they build their conflict wall. We do not have that situation here. There's a whole category of hundreds of cases that deal with public prosecution and prosecution, and then thousands of cases that deal with providing basic legal advice to all the departments and agencies throughout the government. The model rules of professional conduct do not specify the Attorney General can build that conflict wall.
Which
rule? Statutory scheme.
Which rule, sir?
The Guam Rules of Professional Conduct.
Yeah, which rule?
Which rule?
Yeah.
Well, that's what I'm saying. There is no rule for what you just suggested. There is no rule that says the Attorney General, in a situation where you're prosecuting a government official, you should build a conflict wall for all the civil work that you're going to be at the same time doing.
Okay.
The reason why they don't do stuff like that in other jurisdictions, because the government official isn't the client. The government official is a steward of our client, which is all of you, the people of Guam. That is where the defendants are trying to use the people of Guam as a shield to prevent us from prosecuting them. They seek to disqualify me from prosecuting them so they can get another attorney in and probably dump the case or settle it or do something. But that person is not accountable to the people, was not elected by the people. So you lose the legal policy when you set up a conflict wall and prevent the Attorney General, based on the campaign and all the representations made during that campaign, not being able to promise and fulfill that promise by committing that, creating the conflict wall.
Yes, sir. Thank you very much for that answer and the answer to my other questions. I would just suggest if you are confused or unclear how to set up the conflict wall, call Merrick Garland. Thank you.
Thank you. Senator, St. Augustine, sorry. Oh.
Me or who?
Did you want to go next, or there are people raising their hands, I guess, to go?
No, I understand.
Senator Roy waved this time.
No, but we go around in a circle unless we're going to go whoever raises their hand.
Yeah, well, I'm going around unless...
Okay, so I'm next. Okay, thank you. Attorney General Moylan, number one, thank you for your prosecution, okay, and what you do.
Thank you, Senator.
Okay, I'm not going to fault you for prosecution. I like what you're doing. But are any of these attorneys with you prosecutors, or they're all civil?
They're prosecutors. You see, this is one of the arguments we brought before.
I just need to know.
Yes, we have our chief prosecutors to my right. I have Mr. Morris that served on some criminal prosecution cases. He's also handling criminal appellate work.
Okay. I just need to know if they're all civil or they're all prosecutors. That's the key.
Okay.
And
they're both.
They're both. Okay.
Every attorney general under the law, there is no designation under our statutes that says that a particular attorney is only a civil attorney or a particular attorney is only a prosecutor. Every assistant attorney general imbues the authority that you've given the attorney general as being a prosecutor and a civil attorney. If a civil attorney is sitting there as a government official breaks the open government law, that attorney can turn into a prosecutor and handle that, because he's also a prosecutor. She's also a prosecutor because they are a representative of the attorney general.
Okay. And the next one is that my understanding, if any of your attorneys goes out to an agency and is giving legal advice, I need to understand that, number one, when they go out to give legal advice, because they could be prosecutors, they could figure it out already when they need to stop and say, we can't go on any further.
Yes.
Okay? Not later on. The reason why I say that is one of your attorneys gives, if I'm an agency director and I'm going through a procurement or whatever process I'm going through, if they give me advice on what direction I need to go and I'm going down that direction,
Yes.
I can't see how you can turn around and says, well, I'm going to prosecute you for doing this. Wait a minute, you
100%.
gave me legal advice. And that's what I'm getting at, Attorney General.
100%. Your example is exactly why a case wouldn't be prosecuted, because an assistant AG provided the exact legal advice to do something wrong. So the AG has to use the reality of life and figure out whether or not this person was relying upon the advice of one of the assistant attorney generals and was misled. We do not have that situation here. One of the cases in the government corruption area alleged that. Actually, both of them tried to allege it. We don't believe the facts support it. So,
Okay.
but in your situation, that is correct. I would defer in that fact pattern. They would have a problem. We would have a problem prosecuting it.
Major problem. Now, as a, you know, I'm trying to follow along with all the letters. You're identifying February 29, but I'm looking at all these letters and I'm saying to myself, there's a portion here that kind of bothers me. You're going to give legal advice, and then you're going to reach a point where you're going to say, I'm going to stamp, I'm not going to sign because of potential conflict, cannot sign. I'm trying to understand that. If your attorneys are giving legal advice to get this far, if they didn't stop and say to you, Attorney General, we got a problem, I stopped giving legal advice because why? I found that there is reason to believe, reasonable doubt, that there is criminal intent. I can see that. But to say to somebody, to any of my clients, if I was an attorney, well, I'm not going to sign until you sign you waive your legal rights and all that other stuff. I'm seeing it and I'm like, wait a minute. If you're given legal advice and you're going down this road and everything is good, where do you come in and say, give up your rights? Because we could potentially, wait a minute, you should have stopped already to begin with. And you said that already. If you already know that you're going down the road where you could take them to court and prosecute them, that's where the line draws, and you say, okay, we got to stop now. And you're right, you represent the people of Guam. It's not the individual that's in the agency, it's the people of Guam, to make sure that the agency does what they're supposed to do. But it just bothers me that I read this and I'm like, okay, I'm going to give you advice, but at any given time, I have to tell you that I could prosecute you unless you give up your individual rights, and that's not, I'm not comfortable with that.
Senator,
I'm trying to understand your letters.
Thank you. That is not the fact pattern. That is not the situation, and I apologize if it's not clear to you on that. First of all, in your fact, as you're reciting it, you say that my attorney gave me this advice. That's the first problem, is that the AG is not your attorney on that, and that's why we say get your own attorney.
No, I said the agency. Your attorney gave the agency, which I happen to be the director.
Okay.
Remember, I represent the agency like you represent the government. And I sit there and I say, like, Fred, Mr. Nishera, give me the legal advice and the direction we need to go, because that's where we need to go. Because why? I don't want to go to court.
Right.
I want to make sure we're settled and we move on.
Your situation, your first fact pattern that I says, clearly there would be a problem if one of my assistants made a mistake on the interpretations and gave the advice and it moved forward. I know all of our procurements, though, are not in that fact pattern. Their in-house procurement or DOAs, GSA, prepares everything on their own. Then they send it over to the civil division, which starts looking at the procurement records and so forth. So there's no real legal advice other than circling things, sending it back. You need to do this. You didn't follow whatever the requirements were. That's how it normally goes in our office. If the individual was given advice by an attorney, specifically on that allegation that wrongdoing was made, civil or criminal, that would be looked at the AG's office for context, the fact pattern, what happened. And definitely, I would not authorize any prosecution against an individual that was given the wrong legal advice that put him personally in jeopardy of prosecution. That is not what we're seeing in cases that we investigate and move forward towards a grand jury. But, you're going to lose before the jury. They hear that, we're all reasonable. You listen to an innocent person that gets told the wrong advice, they're not going to convict. I have very strong confidence in our juries. They hear that, it isn't going to happen. That's not what we're dealing with. So there's allegations, but from my perspective, I haven't seen any proof in cases that we've been investigating and taking forward.
Okay, now moving along, earlier you mentioned in the very beginning that of the conflict of the letter or the list of possible conflict of interest, I guess, that you can still settle quite a few of the items. Get procurement going, give legal advice.
We're going to get those procurements moving. There was 22 departments and agencies that were identified, so only 22 of them received that type of the 2 letters. And where we come with it is basically we're still going to be approving it, but there's going to be a disclosure on it that we're not, by reviewing the document, we're not serving as your lawyer on it, which is the watchdog function of the AG's office.
And I can agree with that.
Thank you.
And you shouldn't be, but I just don't want to see any procurement halted.
Yeah, that's
because we could prosecute you. You can sign off on anything, and if you find out later that they deceived you, run them to court. I can agree with that 100%.
Thank you, Senator.
But I'm only saying is that because you're called here because of this reason, it's almost like we're in a position where you guys don't need to be here. It's done. And I like to go back to the motion presented earlier that we end the discussion and you all have a nice day. And that's my motion at this point, Madam Speaker, Madam Chair, that we go back and we just end the discussion. The Attorney General already said he's going to do what he needs to do, and let's get the government back on running. And that's my motion, is that we end the discussion. Thank you.
There's a motion to end discussion. Is there an objection? There's an
There's an
objection. All in
objection.
favor, please raise your hand. Motion fails. All right. Senator San Augustine, you have 9 seconds left. Senator San Augustine.
Thank you, Attorney General. I see some of my colleagues like to just talk, given there's not their time, but thank you.
Thank you, Senator.
And thank you, attorneys, for being here. Just do your job. That's all we hope you can do. Thank you.
Thank you, Senator. Senator San Nicolas.
Oh, I'm not a lawyer, but let me give this a go. Thank you for being here, panel. I really like what you do. A.G. Moylan, love those signs.
Thank you, Senator.
Yeah.
I was inspired by you.
I just wanted to, just for clarification's sake, just from so what you did was you withdrew representation or counsel or legal advice to these agencies? Is that what you did?
What we did was, in recognition that 2 government corruption cases are alleging and trying to disqualify me as an Attorney General, we did this as somewhat of a protection so that we can continue investigating and prosecuting government corruption cases until such time as the courts make clearer what are the ethical rules that the Attorney General's office is operating under. Obviously, I've just stated here that I believe the legislature's statutes since 1975 had made it very clear. We did this back in 2002 era, 2003, when I served as the first AG. I think there was 35 convictions on government corruption matters, but this was the first time it was ever brought up. It's just, we are protecting our licenses, being able to go after, to protect the public interest, as former judge, retired Magistrate Judge Joaquin Manabusan put in his decision, serve the public, the people primarily, and then just try to get past this. Let's just move on, get these contracts signed, but make the proper disclosure pending the outcome of those 2 court decisions and maybe an appellate ruling that might be needed.
Thank you, sir. I just wanted to, because I don't think I remember, in my lifetime ever an Attorney General stepping back from his duty to represent the government agencies. I don't think I could ever recall that, but I think you can continue to be a representative or represent the agencies. And if you did had a criminal, because if that individual were to commit a crime, they would have to take up, provide counsel for themselves. So I don't really see there's a problem here.
What's happening is that those people that were, a grand jury found that there's a probable cause for a crime being committed, are saying that the Attorney General violated the ethics rules because, hey, you provided legal advice to my department. We disagree, but the courts are going forward with evidentiary hearings. They're dragging my staff in to have to answer questions about what we internally are doing as an AG's office. So we did this out of an abundance of caution so that we don't lose our licenses to practice law before the potentially the Supreme Court of Guam, as this letter kind of said that the Supreme Court of Guam regulates ethics, in recognition that the rules that the Supreme Court of Guam has issued don't talk about the AG's office, about conflict walls or anything. They treat us like a private law firm. So instead of getting an imputed disqualification problem, we just says, okay, we're not going to represent you temporarily in order so that we can serve the public, the people, the voters, whoever you want to call who is the people of Guam. So that is the reason. I don't like doing it. I didn't have to do it before when I first served because nobody ever raised this issue up. But we looked at it. We're respectful of the Supreme Court's rules and abundance of caution. Thank you, Senator.
All right, thank you. Yeah, thank you for the abundance of caution. I like what you're doing. You know, people did elect you, and I just want you to keep up the good work with those signs. And you know, crime is on the rise here, and it's ridiculous. And you know, any way we can work together to try to put, you know,
thank you, Senator.
Diminish that. You know, that's the kind of place where I want to be. You know, so I applaud your efforts in that regard.
We look forward to working with you. Thank you.
Yeah, thank you, sir. Thank you. Nothing further, madam.
Thank you, Senator. Senator Burnett.
Thank you, Madam Chair. Buenas and Afide. Thank you for joining us.
Buenas. Thank you, Senator.
Yeah, if we could, I just want to read because I know you were here in attendance last night, yes. And I think you were the only individual who got more shout-outs in the State of the Island speech than me. But I just wanted to read this section of the State of the Island address that was centered on you and your office. I know that sometimes government can be adversarial, and the system of checks and balances by which we operate can make us feel like we're governed more by jungle rules than the rule of law. Last week was one of those times. With no warning to the impacted agencies, vendors, or taxpayers, the Attorney General, pending guidance by the courts, withdrew from his Organic Act responsibility to represent nearly 24 GovGuam agencies. Left unresolved, critical departments will lack the basic legal guidance they need to operate. No legal help for the Home of the Sharks still waiting on construction management contract for a new Simon Sanchez High School. No legal advice on the issuance of complex development permits. Potentially no contracts issued for life-saving equipment, drugs, adult daycare. Let's move ahead here. People will suffer from your actions, Mr. AG. Senators, I want you to know that my first call after receiving the AG's letter last week was to Speaker Terlahi. We both agreed that this paralyzing move by the Office of the Attorney General would be disastrous for our people. However, in your open today, you contradicted what the governor said last night, correct?
That's correct. You know, I'm always trying to work with the governor of Guam because she is the representative, the chief executive officer of our government. I try to keep the lines of communication open. I had to respectfully address the governor and say to her, like this Supreme Court of Guam letter was sent to the speaker, that with all due respect, Governor, you're not a lawyer. We lawyers do a different function than the chief executive officer. We do operate within ethical rules, and because of these questions before the courts had nothing to do with the governor, that we need to take this action out of an abundance of caution to protect ourselves, but at the same time to look at case authority, which says that if faced with a potential conflict, the Attorney General must always protect the people, protect the crime victims, protect the people that are suffering from the civil side of government agencies not misspending, things like that, because that is what stops, that's what creates the deterrence that the Attorney General must do by holding them accountable, making them follow the law. The Attorney General is the chief law enforcement officer. It's two hats that the legislature says that the Attorney General must hold. So I understood where the governor was coming from. It's very frustrating from her point of view because she needs those contracts to get out. She needs those procurements to be processed. That's why I met with my staff and we came up with another workaround on how to deal with the situation, still be in compliance and preparing for what the Superior Court might rule on those two cases, ready to go to the appellate courts and plead our case, show as much as we can that the legislature has a say in how the Attorney General and Executive Branch officer operates within the Executive Branch, and then to go from there. So, yeah, she was pretty angry.
Obviously, I'm not an attorney. There are plenty in this room, but someone asked me last night why this never came up with any other elected attorney general. And I'm going to give my version of events. You indicted some people, and criminal defense attorneys are making what I believe to be a desperate move by using this argument, which I feel like we've never brought up before because it's kind of a non-issue. But what's your estimation?
The reason why you haven't seen this before is because the only two times when the Attorney General's office had an actual government corruption division was back in 2003 to 2006 when I first served, and when we restarted it in 2003. So there's a team of lawyers that are assigned for investigations with the investigators. We work closely with the public auditor. Back then it was Doris Brooks. Now it's BJ Cruz. So that can be one reason why. Another reason why you've got a very creative defense attorneys that are throwing it into the court's purview, and as officers of the court, I understand, respect, and we are providing our legal authority to oppose it. So, yeah, that's...
It's a very gracious way for you to put it.
Yeah.
Again, I'm not an attorney, but in my short time here in the legislature, what I have seen is this, and I'm not comfortable with it, I've seen this alignment of defense attorneys and even some of my colleagues here in this body aligning with the administration to kind of really cut the legs off the AG's office and undermine your ability and your authority to do what the people of Guam elected you to do, which is, do the procurements, but to me, more importantly, prosecute the corruption. So I was just a little uncomfortable with the content of the speech and some of the things that we've heard from a lot of these defense attorneys, because I feel like they have a big conflict,
yes,
when it comes to undermining your authority and your ability to investigate corruption on behalf of the people of Guam. So I'm just not comfortable with that.
And first of all, thank you, Senator Barnett. I know you've been very supportive of our office, providing the funding so that we can protect our people. I was disappointed in the governor's perspective, not recognizing, having respect for the fact that the Attorney General exists for a reason. And it's not this Attorney General, it's all Attorney Generals in every jurisdiction in the United States, let alone our federal government. The Attorney General is there to protect the people, to enforce, when you guys pass your laws, you need an enforcer. That is what the Attorney General's duty is to do. And the distinguishing feature between a private attorney and any Attorney General is that a private attorney does not enforce the law, cannot prosecute corrupt officials, and the private attorneys, for a fee, which is a financial bias, will provide the advice to their client and legal services. This is not the unique nature of every Attorney General, and they call them district attorneys also. The bigger states break it between a district attorney and an Attorney General, and the Attorney General may have certain authorities to prosecute or at higher levels for the appellate level. But as I said earlier, there's only a few that are small states like Guam is, jurisdictions, and that have mixed it. The federal government, again, is the prime example of what the Attorney General having prosecution and civil purview, but it's a huge department. It's not like the AG is looking over, or Merrick Garland is looking over the shoulder of the attorneys and so forth. But in essence, the Attorney General of the United States has control of his department. If he has a conflict, that's when they bring in the special prosecutors, and then they cut the control. The special prosecutor has their own abilities, which is still valid in our AG's office when there is a conflict that I need to disqualify the entire office. But what the opponents would have us do is break the office into two Attorney Generals. That's not what the law requires. That's not what the legislature required back in 1975. And we can operate effectively, but we just want to wait for the court's rulings on it. Thank you.
Thank you for that. AG. Yeah, and I think it's interesting that you're, investigating, was it 21 agencies?
Right, and a lot of these came, and if you look at the letter, it was the Office of the Public Auditor that provided 2 pages of all his reports that he was identifying. Yes, most of them came from them, but we have independent investigations coming from the public and from our own sources. But yes, and unfortunately, the governor is one of the departments or agencies, offices that are under investigation.
Is that relative to the Bank of Guam investigation that you're conducting?
Well, that's one that made, I guess, public consumption, but there were other ones. There was the PNC allegations about her office misusing government funds for...
the Typhoon Radio Show?
Correct. Those sorts of investigations, they're coming to our office, and it's creating this situation.
A point of inquiry, ma'am. May we consider that all of those agencies that were named are presumed to be innocent?
Of course.
Mr. Attorney General? Yeah.
And that's why I say investigation.
Yeah, you should have an obligation.
Point of
say
information.
that.
Point of order.
Thank you.
Yes,
Point of order.
I can't hear you.
I thought I had the floor.
You do.
Thank
Please
you.
proceed.
Thank you, Madam Chair. Yeah, so it sounds to me like there is a lot at stake here. And so, when I read the room and I see, who's upset that we called you in here, I think it's very telling. And when I talk about the alignment of defense lawyers and the administration and I mean, I get it, courtrooms where you guys fight, but when I see them using these like instrumentalities of governments and lobbying senators to weaken the office of the Attorney General, I'm just not comfortable with it. But now I want to put on my education chair hat because I'm glad you found a solution, right? And I have to agree, whatever paper you're trying to make them sign so that they can review the procurements, I think I'd discuss with you that obviously, right, the governor was going to advise her directors to not sign anything. And I'm glad you found a new way to address that because I wanted to ask you specifically about procurement that was sent to your office last week. And this is relative to the Head Start program. And they had sent your office a procurement, I think it's upwards of $1 million, and it's for age-appropriate playground equipment to be used at these Head Start centers all throughout the island. And as you know, the program is in jeopardy of being lost because we don't have this playground equipment, and I do believe that we're able to get a waiver now that we put it out to procurement. So I would just ask, are you going to be able to look that over and approve it if it, meets all the standards of your review?
Absolutely, Senator Barnett, and with Mr. Botha present, and I have our head of civil, the supervisors. This is what we do every day when a senator like yourself calls up and says that a constituent has a contract that they believe needs to be processed quicker. We do that in the AG's office. Our normal turnaround time, the standard that I've set with Mr. Botha and his team, is 30 days that we get it in and out. But if people need it faster, I think Mayor Hoffman had a concern yesterday, voiced it to me. I had them work on it this morning. We confirmed that it had already been processed out of our office, and it was back at that department. I think it was Guam Behavioral that was being concerned about. But I mean, this is what we're going to do, what we're doing right now. And in that case, Mr. Botha will mark that down and make sure that that is processed out of our office quickly because it's a time-sensitive matter.
Thank you very much, AG. That doesn't sound at all like jungle rules to me. I appreciate your time here. Thank you, Madam Chair.
Thank you, Senator.
Thank you. Senator Parkinson.
Thank you, Madam Chair, Madam Speaker. I just got some questions. I'm just trying to be clear on the facts here. So, true or false? Your office gave your client legal advice, correct? And then you turned, one of the agencies, and you turned around and indicted them after they followed your legal advice. Do I have that correct?
No, that is incorrect. No, the client, first of all, you've got that mistaken. The Organic Act says that the client of the Attorney General is the government of Guam.
Sir, that's not what I'm asking there.
This is the nuances that we lawyers...
You gave legal advice to the agencies, am I correct? Did you give legal advice to the agencies to
legal
cooperate?
Legal advice was given to...
Was the advice to cooperate with the Attorney General?
Of course.
And did they cooperate?
I'm not sure what you're talking about,
Did the
Senator.
agencies cooperate?
I'm sorry, Senator. Are you talking about a specific case, or are
Yeah.
you talking about in general?
Yeah,
We
these
provide-
corruption cases, did these agencies that you're indicting for corruption, did they cooperate with you before you indicted them?
Well, first of all, Senator, I'm not going to get into the intricacies of these criminal cases because they're ongoing in our court systems. So I will tell you in general, you're incorrect by saying that we represent the government of Guam. The Department of Education, the Department of whatever, Agriculture, they are
But
elements.
you gave them legal advice and then you indicted them.
No.
Is that correct?
Absolutely not.
You told them to cooperate
No.
with the Attorney General and then indicted them. True or false?
Senator, first of all, I'm not going to talk to a specific case, but you're reckless.
I'm just talking, this is all public record, sir. This is all statement
No,
of
it's
fact.
not. No, it's not
Did you
statement-
not give these people legal advice?
The only statement of fact.
Did you tell them to cooperate with the Attorney General's office? Was
Allow
that
him
the
to
advice?
answer if you're going to ask a question.
Thank you. Thank you, Madam Speaker. I'm not going to talk about the specific facts on ongoing government corruption cases. The judges that are assigned to them will make that determination of what the facts are. And that's the evidentiary hearings that were referenced. Senator, I represent the government of Guam per the congressional mandate and the legislature. 3104 and 3109 specifically identify what are my duties.
Okay.
The
I got a
government
question for you,
officials
sir.
are not my client.
I take
and
back my
they-
time, sir. You've answered my question. Is it consistent with judicial ethical standards to advise a client on a course of action and then indict them after they follow it? Is that consistent with judicial? This is a hypothetical. Is that consistent with the judicial ethical code?
A hypothetical question that you give a government official advice that's going to have them break a law is not what we do at the AG's office. We provide advice consistent with our interpretation of the statutes as passed by yourself and the Guam Legislature. So your question is inherently biased by your saying that we are providing advice that breaks the law to government officials. I disagree with that. Not under my administration. And if
But
I
it
find
is
out
true
that
you
any
advised
attorney-
them and then indicted them. Is that correct?
No, it's not. I know of no situation, especially under my administration, where any one of my lawyers or deputies has ever advised a person and we've indicted them. I can't speak to former AGs, but I can tell you with my administration and my understanding of the rule. Excuse me. My understanding of the rules for attorney generals don't give advice that breaks the law. You've got a bad attorney general if you have that. Okay?
That's very, very succinct. Okay. What is the repercussions for a lawyer that violates attorney-client privilege?
The repercussions is you will be questioned, and then the Supreme Court of Guam ultimately will decide whether you've broken the rules.
And if you've broken the rules, what is the consequences?
It varies. It
Is
could be just a warning, it could be a suspension, it could be a public reprimand, it could be a private reprimand.
Is disbarment one of the possible options?
Absolutely.
Because you said something that I thought was very interesting, that you wanted to pass this law, introduce this law to keep your license in an abundance of caution. Are the actions that your office has taken have put in your legal licenses at risk?
I don't believe so. That's not our legal position.
Is there currently an ethics complaint or investigation opened up against you, sir?
I'm not aware of any. Are you aware of something?
I'm asking you, sir.
I'm sorry. I'm not aware of anything.
You're not aware of anything?
No.
Okay.
Should be. Attorney General. Ma'am, if I may, there is no quorum.
Point of order. Point of order, Madam Speaker. A quorum is not needed unless there's a voting. So the continuation of this discussion can continue on. And if you need our attorney to school you on that, Senator Fisher, you can ask her.
I would ask the Sergeant of Arms to ascertain whether the other senators are in the building or not, and to let me know, please. Yes.
So why is there an abundance of caution and a rush to introduce this legislation to protect your licenses if there's no investigation or ethics complaint against you folks?
Senator Parkinson, I did not ask to be here. I did not introduce this bill wholeheartedly. We have taken measures in the AG's office to deal with our internal conflict checks, our court cases that are out there. The proposed legislation was because an emergency situation was stated to us, so we gave something out that we asked you to consider. But as you know, bills that are introduced oftentimes never make the floor. That was the reason. And the reason why is because I don't want my license to be suspended, dinged, or whatever else. That's the reason why we came out with a proposed legislation.
And you think your actions may have compromised your license?
What actions?
Why are we introducing this? What is the abundance of caution we're worried about?
Well,
is there a concern for your legal licenses over the actions of the AGs recently?
I think when you see the December 28th letter and actually read it, and the December 29th letter, you'll see there is a concern. And out of an abundance of caution, I would rather not violate the ethical rules than violate it. That's what abundance of caution means.
Is there any other jurisdictions in the country that allow attorney generals to violate attorney-client privilege by statute?
Well, your question again is loaded.
So I'll take it that there's no other jurisdiction that's done this.
Well, I can't understand your question, sir.
Has any other jurisdiction done anything like the legislation you're proposing?
I think in some ways they do.
In some ways, but there's no precedent for what you're doing, you're saying.
That's not what I'm saying. I'm
saying what is the precedent for what you're doing here?
Our office has already identified at least 3 states that have statutes similar to Guam's where the Attorney General has the prosecution and the civil authorities. We haven't gone as far as being able to answer your question on other jurisdictions, but by fact, if you read the 1975 enabling law, it clearly has the Attorney General as a public prosecutor and providing legal services. And again, you confuse yourself when you say my client is a government official. They are not my client. My client is the people of Guam, government of Guam. That's where your errors are occurring.
I have a question for you then. You say you don't know about
I'm sorry, Senator. We're going to take a 1-minute recess. I haven't got word back from Sarge. 1-minute recess.
recess until tomorrow.
On that motion, we will recess till tomorrow at 9:30. Recess till tomorrow, 9:30.